Now, the last 24 or 48 hours has put the judiciary in bad light and also in good light. One was an action by a judex, a judge, and that damage that was done, quote unquote, is now being attempted to be repaired or being repaired by the justices of the appellate court. What am I talking about? This issue about deregistration of political parties, the court order from Justice Peter Lifo directing INEC to deregister political parties for not meeting the criterion, in his view, of 225, Section 225A of the 1999 Constitution. Mr. Liberos Oshomah is right here in our studio. He's a legal practitioner. He helps us to break things down. Mr. Oshomah, thank you so much for coming on the program.
My pleasure. Good to have you.
Good to have you. And we're going to leave you to do all the legalities today. But just to give our audience a bit of a background, I was listening to, I think, one of the lawyers who was in court. He was trying to explain how this thing got even to the appellate court. First, he said, I had to write it down. He said these lawmakers, they call it Association of Former Legislators, had filed the suit in December last year. And when they discovered that they are non-juristic persons, they can't litigate this issue, they, on their own, amended and added incorporated. And on their own also, in the initial filing, there was no accord, according to him, there was no ZLP or so. Also amended it on their own without the court order. And then it was challenged by the defendant. But well, Justice Lifo went ahead, and granted those amendments, which is why they appealed. And that appeal was granted. And they said they presented that what was granted by the Court of Appeal, which was stay of proceedings, and the case was to be heard, I think, in October. Despite their position and canvassing, Justice Lifo still went ahead and did what he did. And that aspect, now the Court of Appeal has now sat over it and said that was total nonsense. So what do you mean? Is this, because it sounds like political litigations are becoming more like a downside risk to our jurisprudence. Is that what you see?
Yes, yes. It's always been like that. You find out that Shehu Sani once said something that the day the court stops determining candidates and winner of election, politicians will abandon the courts. And so there's always, unlike other jurisdictions, there's always a ready-made or a pool of lawyers available to politicians, and also, unfortunately, also pool of judges available to them, people like Justice Lifo. I will say this because the Court of Appeal in their words yesterday described his action as judicial rascality. And for every lay lawyer, let me use that word, when I say lay lawyers, even those who don't go to court, they understand the hierarchy of court. And so, because court now determines leadership in both market union, the drivers union, NUTRW have their own also. So this political litigation has permeates the length and breadth of all associations, including the NBA. And so, even this matter, let me start by, let's even read that section for the benefit.
Yes, our producer will put it up.
For the benefit of our viewers. Section 225, because paragraph A, because it's been interpreted by the highest court of the land, the Supreme Court. The Independent National Electoral Commission shall have powers to deregister a political party for breach of any, he says, for breach of any of the requirement for registration, failure to win at least 25% of vote cast in, then that's paragraph B. It now has all the sub-item. One state of the federation in a presidential election, or one local government of a state in a governorship election, failure to win at least one ward in chairmanship election, one seat in the National or State House of Assembly, or one seat in the councillorship election. And the Supreme Court, in the case of NUP, National Unity Party, and INEC, just recently, interpreted this section to mean that all that is required is just to win one councillorship seat, one. That's all it's required to remain as a political party after election, one councillorship. And INEC, in its own affidavits and supporting document deposed to before Justice Lefu, went ahead to depose to affidavit that all of the 5 political parties listed had met the threshold of not just winning one councillorship, but House of Rep, like that, the case of ADC, and then exhibited the results of those elections. Then the case of Accord, exhibited return, a certificate of return issued by the local, the state independent electoral commissions in those cases. The case of Zenith Labour Party exhibited,
that's what, Abia.
Yes, exhibited the certificate of returns issued. And that's the agency that is empowered by Section 225, Paragraph A, to deregister, saying, look, we have deregistered those that did not meet the threshold. And so, all of these ones have met the threshold, and these are the documents to actually show that they met the threshold. So what justice, despite all of that, despite the fact that the Supreme Court had interpreted that section to say, once you win at least a councillorship, and then you have met the requirement. And mind you, the Supreme Court agreed with the Court of Appeal and the Court of First Instance also. And aside that, about 3 or 4 federal high court, one in Uyo, one in Owerri, had also ruled that, because there were other applications to deregister some political parties, had also ruled that you cannot, they do not have the powers to so do once it has been shown, not even winning, that you are challenging an election, that a political party that did not win, but they are in court challenging the process, that the court do not have the power to deregister such a political party. But despite all of this gravamen of documents and argument before Justice Lefu, he went ahead, just like you described in court. I even learned he went ahead to say, well, I will do whatever I want to do, let the Court of Appeal do what they want to do. This clearly shows that maybe we are seeing unwritten hands somewhere beating the drum, because the judge cannot close his eyes to all of these authorities, all of these documents placed before him. And also, lastly, the Court of Appeal ruling asking him to stay proceedings pending the hearing and determination of the preliminary objection that was filed before him, which he overruled, and that the matter was adjourned to October. He still went ahead despite the hierarchy of court, even in some cases where without even an application or a ruling to stay proceedings. I've been in matters when once appeal is entered, record is filed, and there's an affidavit to show that appeal has been entered. The court will see, the Court of First Instance will say, well, I will not want to be on a collusion course with a superior court. And so it is a notorious fact that once appeal has been entered, the matter is now before the Court of Appeal. The Court of Appeal is seized with the fact of the case, and we'll adjourn this case, sine die, like my friend and brother, Leonard Sikh, High Chief Abdul Malik would describe it, till sinners die. Until the lower court will come back to the matter. But in this case, the parties did not just file affidavit of that appeal had been entered. They also, the higher court, gave an order instructing, directing the judge not to touch that case.
Mr. Oshomah, I've been processing in my head. Yes, I'm still processing in my head because I'm still trying to process.
That is the height of judicial.
I'm trying to process I'm trying to look for an excuse.
That is the
for
height.
Justice Lefu.
That's not just the height of judicial rascality. It is an outrageous display of irresponsibility by a judge against a superior court.
Because okay, go ahead, Bukola.
I'm wondering, because you've read out the Constitution, Mr. Libros, and it says that INEC shall have the power. INEC shall have the power to deregister a political party for the reasons outlined in paragraph A of 225. And yet, this association of former legislators went ahead and initiated the suit. Talk to us about the matter of locus. Based on what the Constitution says, did they have locus standi, as you say in law?
First and foremost, is this association registered? That's the first thing. Is it a registered association? Is it known to law? That's where the issue of being a juristic person comes in. Are they a juristic person? Do they have the power to exist in that name? And that's why the parties have challenged their locus. The first thing is,
if they were
are you a person properly so called?
If they were registered, would they still have locus?
Then the next question is, we also know, because they are saying they are not registered. So we know that even for an association, when you bring a matter in the name of an association, in most cases, you're asked to file in the name of that association as registered trustees of that association, because it is the registered trustees of that association that are empowered by the association or by the law to file for and on behalf of that association. And then secondly, this association, every matter that comes to court, the first question the court will ask you, what injustice have you suffered? What wrong or what damages will you suffer if this is done or if it is not done? They also had not been shown what damages the association would suffer to cloak them with the local standing to say, okay, we deregister this political party. They are also not members of the political party. They have not also shown that they were part of those who made these laws, and that so they are more Nigerians than other Nigerians, so want to enforce the law. They are also not shown that they are members of the National Assembly, or they were members of the National Assembly that made this law. So in that vein, they are attempting to enforce a law so made by them. Just anybody can bear any name. Anybody can come up and say, two of us or three of us here can just write any name and say we belong to that association. You know, when some people issue press releases, concerned citizens and all of those, you know. So anybody can bear any name. That's why in most cases, the court will ask you to exhibit in your, not just say we're a registered association, where's the certificate of registration, and what injustice have you suffered. All of these were not done, and the parties, the defender, the respondent in this case, filed a PO, preliminary objection, to challenge the local standing of the applicant, and the court overruled. They went on appeal to say, no, this is not right, and the court said, well, we don't have time to look into this matter now. There are so many other cases, and vacation is approaching. And from July, first week in July, we'll be on vacation. So let's come back after vacation and look into it. But lower court, stay action. But the judge said, no, I don't care what the higher court would do. I think at this stage, the NBA should not just fold its hand, because when this is the only profession that we have as lawyers, and if it is destroyed by other lawyers and judges, what that would mean is that all lawyers, maybe someday, will become car washers and you know, what have you. So the NBA as an association should mobilize lawyers to boycott courts of judges like this. They've done it before. In the days of Akabashoru, NBA would ask lawyers to boycott such courts, because this is not disrespect to lawyers. You can say judges, there should be mutual respect, but sometimes, you know, some things can happen. But this is disrespect to the hierarchy of court. So if we allow this to pass, tomorrow the Supreme Court can give a judgment, and then a high court will say, well, I don't care. The Supreme Court can say stay action in a matter. The high court will say, well, I don't care what the Supreme Court will say, and let them do their thing. I will do my thing. And then secondly, democracy is about participation. If you keep deregistering political parties, that's no longer democracy, but dictatorship. At the end of the day, somebody can sit down and just deregister all of the opposition party, and then now you don't have just one party. So that's no longer democracy. So you are to contend with just one party.
Yeah, I want to go back to Justice Lefo. So in my head, I'm trying to look for an excuse for him. Because what has just happened, you don't even need to be a lawyer to understand as simplistic as this can be in terms of what he should have done. But he still went ahead and did what he did. What do you think he was relying on? Let me use the word in law. Look, because I was not in court.
Let's not.
I'm trying to explain.
Sometimes, as I am so angry seated here.
It's confusing.
Sometimes they tell you as lawyers you should be circumspect with our words, especially as a senior lawyer when you're aspiring to the INABA. And then sometimes you look at these things, you say, you know what, I would rather not be a member of the INABA than just keep quiet and allow injustice to pervade the land. Because if it subsists, you won't even have a profession, not talk of becoming a member of the INABA. So, to answer your question directly, certainly there are some unseen hands that are detecting here, and I will not, I say this with all sense of modesty, that I do not understand why a judge would want to throw his name and reputation to the dogs with this kind of, by exhibiting this kind of behavior and disrespect to a superior court, despite an order saying stay action, don't do anything. So we all know this is not just about you're saying documents different, because all of these documents I have stated here were before the judge. They were filed in an affidavit. Even INEC said, look, no, there are certificates of returns, there are results, there are court processes challenging election, and so we do not have that power. Moreover, we have also deregistered some political parties who have failed to meet the threshold. That is the agency that is responsible for the deregistration. The agency you are directing, you're telling them no. Despite all you have seen, despite the document, I will not do it. Certainly, that is no longer law. The judge was not looking at law. Maybe some persons, some unseen hands somewhere, or they are probably, it's like kidnappers holding somebody to ransom and insisting that he must do their bidding, or blackmailers blackmailing him. And so when it gets to a level where people will now begin to blackmail judge, and the judge will throw caution to the wind and say, well, maybe my life is at stake here, I think the DSS, the NJC should first and foremost instruct the DSS to investigate if there's anybody blackmailing the judge, if this life is, at risk, if any member of his family has been kidnapped or their life is at risk, then let us clear all of that to ensure that he's not being blackmailed to do this, or that also let there be a conclusive investigation. And pending all of this, the judge should be asked to step aside by the NJC pending this investigation, because forget about the ruling now, the judgment. Maybe that's the way he's saying it. But the fact that there is an order of a superior court asking him not to take any step in the matter. And despite that, that was why the Court of Appeal did not have kind words for him yesterday. And despite that, he went ahead. It is like telling a Court of Appeal, the Supreme Court, to go to hell. And so for you to do that, certainly there must be something. So I think this is not just a matter of, oh, look, the hierarchy of court, the judge probably saying it differently. This should be a matter where the NJC would, step back a little and say, look, this doesn't happen. So for this to be happen, maybe somebody's beating drums somewhere. But let us clear out the fact that it's not a threat. So let the DSS, not police now, not EFCC, so that they also, you send EFCC after judges. Let the DSS do a discreet investigation into, affairs surrounding this judge, whether there's somebody blackmailing him somewhere, whether there's a threat around him, to warrant him putting his career and his neck on the guillotine. This judicial suicider.
Strong words there. And speaking of drums being beaten, I believe the ADC is fingering some very highly placed individuals behind the suit, and they've also talked about the Attorney General of the Federation being named somewhere in the suit as well. But that's another matter. I want to pick up on your earlier thoughts when you said, democracy is about participation, and we shouldn't be seen to be deregistering political parties for any reason. Again, I refer to Section 225A, and the language there really is very strong, conferring enormous powers on INEC. He says that INEC shall have power to deregister a political party for breach of any. And so this came up yesterday when we engaged with an ADC chieftain, and we're wondering if this has to do with, borrowing Jeffrey's words, conjunctive or disjunctive. Is it an and or situation for you? I'd like us to expand
it's not me now.
Your legal, no, we want to know your legal insight. So is it any one of all those requirements listed in 225A, or all the requirements if they don't meet one or they don't meet all?
The law is what the court says it is. So the court has interpreted that section. Starting from the Federal High Court, 3 Federal High Court justices were unanimous on the interpretation that any of these criteria, and the list being that you must win at least councillorship. So what it means, even the Supreme Court in NUP and INEC, National Unity Party and INEC, reported in Law Pavilion, also concurred and said any of these criteria. So once you win councillorship,
you are good.
You are good to go. So because also there is no provision in our law for a candidate or, sorry, a political office holder to be in office without a political party. So once you have been elected on the platform of a political party, if that party is deregistered, that means you are partyless. So, and there is no provision for independent candidature. So if the political party has a councillor at all, so you can't deregister it, because if you deregister it, that means you have a councillor who is without party. So that's not the provision of the Constitution. So also, if you take it a notch further, INEC, as we speak, has already registered more political parties. INEC is in the process of conducting another election. And INEC also had conducted verification on these political parties. And in compliance with Section 77 of the Electoral Act, these political parties also have submitted their electoral register, their party register, to INEC for verification. And so they have also conducted primaries and submitted some. Most of them have not submitted. Some have submitted their list of candidates to INEC. Then, how do you, at this stage, deregister such a political party? Because when you deregister that party, what it means is that you have aborted a child in the labor room. Because INEC, as we speak now, is in the labor room preparing to bet 2027 political office holder. So, at this stage, this is not the stage you want to abort the process, because INEC had initiated the process on your mark set, and because election starts from the timetable, not just on the day of the general election. So that process has started. INEC had registered other political parties. After the election, they had deregistered. And then now they have started another process. And that process had begun since this year, early this year. And even the timetable that was released by INEC that had been nullified by the same Justice Lifu, INEC had appealed the judgment to say, no, there is a process to this thing. And once you deregister that party, what it means is that all of the candidates of that political party, you have denied them the opportunity of participation in a democracy. And so if you deregister 5 parties today, and then it is not challenged, it is allowed to stand, tomorrow, despite the fact that these political parties have candidates, what it means is that tomorrow you can sit down and say, you know what, all of the other political parties apart from the ruling party, we deregister them. Wow. So once you do that, you throw the country into a serious anarchy.
So the ADC was right when they said in their response on the first time the judgment came that this is playing with fire.
Yes, it is. It is, because if you saw the desperation of the 1983 election, how the mudslide and landslide victory that truncated our democracy. We should also not toy with that, because those in government today are the people who fought, who claim to have fought for democracy. Some of them we knew actually fought for democracy. And mind you, before I leave here, I would say this, even though a lot of people don't like it. For the purpose of inclusiveness, even the military government in 1998, 1999 allowed all shades of political parties. You remember, in 1998, there were criteria for registration, and those criteria were even more onerous than this. And one of those criteria was that you must win at least 10% in 24 states of the election of the in the national election. Local government elections were conducted in 1998. Out of the 3 major political parties, only 2, PDP and APP, crossed the threshold. And AD did not meet that threshold because they only won 10% of the vote in 14 states. But the then government said no, because of the issues of June 12th, it will not augur well if you deregister a political party from the Southwest. And so they allowed it. And I also would think that for whatever reasons, especially now that the major opposition party, PDP, is in comatose, thanks to the members of the party and thanks to one man, Wiki, now that other political parties are attempting or trying to come together, I think it would have been better for anybody not to want to interfere, not even to talk of a judge, to want to interfere at this process, at this time, with the deregistration of a political party. Because if there is anarchy, if there is chaos, even you as a judge will not be able to see it. It happened in Liberia. When the problem was brewing, judges who folded their hands. But when there was crisis, they were all in the refugee camp. In the refugee camp, there are no judges, there are no lawyers.
We're totally out of time, Mr. Libros. Totally out of time.
Yeah, indeed, we are out of time. So INEC has not dropped the ball here because the parties have been able to show cause that they are in compliance.
We must give INEC kudos on this one. We must give them kudos.
In 60 seconds, since this is a stay of proceedings by the appellate court, where is this case going now? Stay of execution. Yeah. So where's the
certainly
case?
The matter has gone to the Court of Appeal, and so the Court of Appeal now has said, you know what, we will not take this rascality from a junior. We'll stay execution of that judgment. So I also would think INEC, haven't deposed to that affidavit or the document, will certainly appeal this.
But there are other issues. We'll bring you back to other issues. You raised some storm on the social media, but we're not going to explore it today. Liberals Oshomah, thank you so much for coming on the program.
My pleasure.
Very fiery legal practitioner. You know, if it has to take this, he will say it. Thank you for coming on the program. Let's take a break. When we come back, now that the oil prices have gone down below, crude oil price has gone below $80 per barrel, Nigerians are now looking at the petrol stations, say, when exactly are we going to feel the impact of the reduced price? Well, the people who understand how it works will be joining us in just a moment. Stay with us.